Right. So what have we got here then? We've got the better version of the regulation.
Yes. With titles that are legible, etc.
Yes.
And then
An old-fashioned call for your judgment said, "What a pity we didn't have that this morning."
well,
thank you so much for getting to us now.
Trying to be helpful.
And we've got
this is the 2000
regulations.
Yes.
As well. That's good. Thank you so much for doing that. Yes. Okay. Where do we go now?
My Lord, into the grounds, and we can be brief. I had forgotten before lunch that we had also the Conciliation Board opinion of the Administrative Commission returned to us, and I may have to make some. I have some submissions on that.
Well, I think we're ahead on time, Mr. Berry, at the moment, because I don't imagine this board's going to have to go through the regulation in the same detail.
Great.
Feeling our way.
What a disappointment.
And my Lord Justice Lewis asked before lunch about ground 4. It has been overtaken by events in the sense that there's no longer any dispute about whether there's a conflict of views, and that was the basis of the referral. Yeah. So, in our position, is it's solely of academic interest. And
so we don't need to deal with it.
Really. Doesn't need to be determined by the court at this level.
Right. Okay. So, what do you want us to look at next?
Well, my Lord, just before we get into materials, just to make one submission about our approach to fundamental rights, which differs in one degree from what was said below, is that we are not saying that there needs to be a tailored analysis of the child's particular circumstances. That's no. If my lords and my lady will recall that there was such an approach in the Upper Tribunal. That's not pursued before this court.
Okay.
It's purely an interpretive approach to the overall scheme. But in any event, we say fundamental rights, buttressing issue here that happily coincide with the purpose of construction we've advanced.
The difficulty with interpretation, whichever interpretation you give is going to favour children in one case and not in another case. If you look at the best interest of Mr. Stellamere says it's not so true. Unless somebody has to say that.
I'm going to leave that to Mr. Stellamere. There is one statutory provision for us just to look at, which we didn't look domestic, which is section 72 7B of the Social Security Contribution Benefits Act, which is tab 2 priorities, and page 12. And it's our case that we satisfy this provision. We're not saying that we can succeed if we don't satisfy it. Just to be clear, that we say that the UK is the competent state for the payment of sickness benefits. So there's no argument here about what you do in default from us. It has so, my Lord, in respect, I was going to take ground 2 first, because that concerns the independent right to benefit, and it makes logical sense. It should have been ground 1 from the start, but it's and you have the essence of our submissions on why there's an independent right to benefit in terms of how we've gone through Article 11. If my lords and my lady if it were of interest, I can take through each stage of how you get through personal scope, material scope, state of determining the single competent state through the state of residence, and how you therefore get to the competent institution and the competent state. But it may be that that's not necessary in the light of touring through the regulation in the way that we have already done before lunch.
Take whatever course you want.
Well, my lord, in that case, if I just give you the example very briefly of how the appellant succeeds, so we can see how the scheme works in practice. The appellant, for the purposes of Article 1J, the United Kingdom is the state of residence, where the appellant habitually resides. She falls within the personal scope of the regulation, as she is a member state. So Article 2, because she is a member state national living in one member state who has been subject to the legislation of one or more member states. She's within the material scope, Article 3, because we're dealing with a sickness benefit that falls between Article 3, 1A. She, in determining the single competent state for her purposes, looking at Article 11, she's economically inactive, and so in default we go to Article 11.3 E. And so to complete the analysis, once we've got to that, she is subject to UK legislation. The institution that applies the legislation is the Department for Work and Pensions. The Department for Work and Pensions is also a competent institution. That department is within the UK, and therefore the UK is the competent state. And so you can see how you can trace through the way in which individual entitlement arises. There is, in respect of our submission, that Title II constitutes a complete and uniform system of conflict rules which determine which single state applies. There are numerous examples in the case law of a reiteration of that of that statement being made. But in if we turn to the authorities in tab 24, we can see one of them in the case of SF against Inspector von der Belastingdienst. Not sure how you do that in the language in question, but it has.
Belastingdienst?
Yes, but I'm not sure if it's Dutch rather than German, so I'm not sure how to.
Wasn't my pronunciation convincing enough?
I personally, I'm not sure.
Anyway,
tab 24.
Yeah.
The page 491. The case concerned a Latvian worker who was remained resident in Latvia, but was sailing on a vessel flagged in the Bahamas but established in the Netherlands, and the Dutch authorities were trying to assert jurisdiction for the purposes of their social insurance scheme. So it's not a case I'm even vaguely suggesting is relevant. But in page 497 of the authority, we see its judgment of the court is you see the passage.
Mark passage.
Paragraphs 32. Paragraphs 32 to 33.
Would you like us to read those?
My lord, yes.
Do sit down.
Thank you.
Okay.
My lord, grateful. So it's just an illustration of the proposition that Title II is a complete and uniform system of conflict rules. And then if we turn to a domestic authority of the Upper Tribunal at tab 29 and a
TG.
yes, indeed, and case about entitlement to disability living allowance. We just see the one passage which I would direct my lord's attention to is paragraph 8 of that judgment.
So where my mind is elsewhere.
Apologies, my lord. In tab 29 of the authorities bundle.
I was thinking about something else. I'm so sorry.
Yeah. It's, Secretary of State for Work and Pensions against TG, a case concerning DLA that was determined in the Upper Tribunal. And maybe it's helpful to read paragraphs 7 and 8.
Well, it's really the last passage on reflection, isn't it? So,
Yes.
right.
Yes.
So sort of apologia.
Yes, my lord. Yes, yes.
And that fits your interpretation of the
Indeed.
regulation. Title 2 is a, whatever phrase you used, uniform
Paid. Yes.
uniform code of conflict rules. And Title 3 makes consequential provisions,
Indeed.
consequential upon the decision taken under 2.
Precisely. Yes. And so that's consistent with our analysis as we submitted it before.
And the next sentence. So before Article 21 can apply, there must already be a competent state which will have been identified pursuant to Article 11. That's your case in a nutshell.
It is in a nutshell, yes. And
has that been approved by anybody else?
Pardon, my lord.
Has that been approved by anybody else? That sentence.
Well, only
before today.
Not here. Of course, the idea of Title 2 being a complete and uniform code is from the Court of Justice, exactly. Yes. And I'm reminded it's in line with what was observed by Lord Justice Richards in Conavod, which is in the.
Well, do you want to take us to
yes,
that?
Yes.
In a minute. Are you going to cite a Baltopia case?
Well, that is not individually.
Okay. Beyond, because it's cited in the Dutch case that you just took us to.
Yes, but
you're not going to take it. Okay.
Happy to rely on the Dutch case for the proposition.
Can you take us to what Lord Justice Richards says about this?
Conavod is in tab 31 of the 604, and then page 604 within it. So this is a case where the claimant had worked in the UK, become entitled to a state pension from the United Kingdom, then moved to Cyprus, where he became a carer for a British citizen resident there and sought carer's allowance. So it's not the same again, but
paragraph.
I'm just turning to it.
33.
36 and following.
36.
Under discussion.
Thank you. Is that right, Mr. Berry?
Yes, ma'am. It's tab 31.
I'm just trying to think whether paragraph 39 supports your interpretation of Article 21 or Mr. Delamere's. Or whether it is not on that point at all.
I don't think it's on that point.
On the facts of this case, there aren't any family members because it's simply the individual applicant moving to Cyprus and then seeking the benefit, effectively exporting carer's allowance. So
the competent institution for his pension must be the United Kingdom, but leaving that to one side, his competent institution for different benefit, the carer's allowance or whatever it is that he wanted, because he moved to Cyprus. So you can have a competent state for different benefits. Yes, I know Mr. Delamere is looking shocked that I only just realised that. But that is the consequence of that kind of odd. Yes.
And in a sense, you can see in a contribution-based system, contributions may be made for different things.
Yeah.
Yes, well, that's
Makes complete sense.
You can see that.
there's a coherence there.
Yes. So it's an illustration of how the approach to Title II.
Right.
So all of those submissions were really heading under the rubric that one goes to Title II to determine the single competent state, and then that there is an individual right of entitlement. That's our ground 2 point for the reasons that we've already advanced. The remaining 2 grounds on which are live before your lordships and my lady today. Ground 1, which is about the operation of Article 21 in circumstances if you get to that. Of course, our primary submission is that you don't get to Article 21 because of the individual entitlement of the child. You don't have to decide between the parents who takes priority. But the question of who ought to, the first point between the mother and the father, in the terms of how Article 21 provides no explanation as to how you decide where there's more than one derived right. It simply is silent. It doesn't say anything.
There isn't, the mother's position is simply irrelevant here. For the purposes of the care component of Disability Living Allowance, the United Kingdom legislation does not give the mother a right, and that's the end of it. So the child can't get a derivative right. Indeed, that's why it's the child's right. The derivative right, if it exists, would be the right she gets from the father under Belgian legislation.
My Lord's point, it's certainly true that under the UK national legislation there is no provision for the mother. It's also true in Belgium as regards the father. There's no sickness benefit to be paid to the father.
Yeah.
And it's exactly the same situation. In fact, my Lord's point drives us to the conclusion that neither mother or father are relevant on the facts of this case.
No, but the difference is the legislation governing this benefit gives it to the child in Britain. The legislation governing care benefits don't include care benefits for disabled children in Belgium, apparently. But it's the question is which legislation is applicable. And the legislation applicable here gives it to the child, not the mother.
It does.
It seems to me to be quite irrelevant. If it gave it to the mother, the child would have a derivative right, but when it's given it to the child, I just have difficulty in understanding why the mother's position is relevant.
On the facts of this case.
On the facts of this case, I understand my Lord.
It would be different if she worked in France.
No, it's enough to be within the chapter to be insured for one sickness benefit.
Yes. Yes. I mean, the regulation, the right which you derive, if you're going to derive a right, has to come from the regulation. There has to be some provision. I appreciate my Lord's point that as it happens under UK law, it's an empty shell because there isn't a...
No, that's not my point at all. My point is stop looking at whether you get money. Look at the legislation. There is a system of legislation in Belgium, and it may be that it doesn't give this benefit, but the father is subject to that legislation, and if the child has got to go with the father to the economically active state, then the child doesn't get anything. There is legislation in the United Kingdom. As it happens, and it may help in this case, it's legislation under which the child has the benefit. And that's what you're looking at. So I don't know why you're complicating it by saying we're going to look at the United Kingdom legislation. It doesn't actually apply to this benefit for this person, but nonetheless, she's got a derivative right to something that the person that she's deriving from doesn't have. I just don't see the need for it.
I suppose this, well, it may be right. I mean, on our analysis, Article 21 plays no role at all, of course, but
No, but this is all different thing. I mean, how could you win on this case by relying on the mother rather than the child?
You couldn't.
No.
Under the, of course, it has. My only supplementary observation to my Lord's point is that that it's true that the UK national legislation specifies an individual, and it is to be the child rather than the parent. That's one way in which the mother is irrelevant. My only supplementary observation is the father is there's nothing at all in Belgium where it's specifying anybody at all.
No, but that's the point. You're looking for money, and I'm looking for legislation. And the legislation that applies to economically active people in Belgium don't give this kind of benefit. The legislation in England does, and the question is which two sets of legislations apply to this child. But the position of the mother doesn't help you at all on that question.
No, my lord, it doesn't. And I suppose my only observation, again, in respect to the father, is there is legislation in Belgium. It's just in the sense that it just doesn't confer a benefit, a sickness benefit in this area, in this particular area. The father can be subject, in principle, to the legislation of Belgium, and as it happens, Belgium says nothing on this particular topic. The mother is subject, in principle, to the UK, and the legislation says it's not you, it's the child. So there is absolutely a difference in approach. There's a bit of positive law, if you like, in the UK, and perhaps an omission in Belgium. But the father is subject to Belgian legislation, which happens to choose in...
I don't think you and my lord would disagree.
No.
No, I don't. I'm just saying, in a sense, if I can encapsulate it, what's sauce for the goose is sauce for the gander. And that it's true. But I suppose, for the purposes of our submission in Article 21, our submission is that there isn't a priority rule in Article 21 as between the parents, and one has to reach a conclusion based on principle. And that if they're in the absence of a priority rule that's expressly stated on the face of the article, what are you going to do when you have two parents, whether they're one resident, one non-resident and economically active, or whether you've got two economically active parents in two other member states, as was the example canvassed before lunch. And we say that a best interest, the one that does least harm to the best interest, is to say in principle, you can look to the mother were it to be relevant. But I absolutely take my Lord Justice Lewis's point that it's not relevant. Fact, it's not relevant. No. But it's an illustration of why one ought not to go to Article 21 in order to determine a single competent state for Article 11 purposes. In other words, that the proviso in Article 11.3e, that without prejudice proviso, can't simply import Article 21 to determine the single competent state, because what you do with both parents.
That's a better example with the grandparents in England and two.
Yes. My lord's
that
example.
Is a genuine situation where you've got three sets of legislation.
Absolutely.
You've just taken us to a whole lot of authorities that make it very clear that Title II is the comprehensive code, if you like, that determines priorities. And the last time I looked at it, Article 21 is in Chapter 3.
My lady is right.
Title 3.
Isn't
that the short answer?
It is the short answer. It's not the answer the Upper Tribunal reached, and we're appealing against their judgment. But it's yes, my lady's right.
But that's an answer.
That is the answer.
So really, are these submissions really directing at what the Upper Tribunal said? Is that right?
Yes, the Upper Tribunal assimilated Article 21 into Article 11 in order to determine the single competent state effect.
We haven't looked at what the Upper Tribunal said. We've approached it through the regulation. Do you want to show us where you say that the Upper Tribunal went wrong?
Yes, indeed, just briefly. But of course, if we're right for our construction, then the Upper Tribunal is wrong. But absolutely,
yes. But it would be helpful just to pinpoint exactly where you said the Upper Tribunal precisely went wrong.
Page 53.
Yeah. So if we turn to page 53, paragraphs 30 to 36.
Right.
May just be helpful to read it.
Yes, why don't we read 30 to 36? Is that what you'd like us to
Yes.
read? Why don't you sit down again? Mr. Berry, thank you. Right. So, obviously, if we go to his reasons, beginning at 33, a lot of this, or some of this we've covered already.
Yes. So, of course, his holding is at paragraph 32, as my Lord indicates.
30, so we of course were troubled, or at least we were troubled. We looked at 11.1 and how that impinged on
Yes.
11.3. And you dealt with that point.
Yes.
Through the article. He says that's buttressed by the recitals he quotes.
We have been through the scheme which deals with whether
For my part, the part we haven't looked at so far is the comparison with the previous regulation.
Yes, that's our ground three, and we should
Coming on to that in a second.
Yes, absolutely. It has. But the rest of it is the analysis that we look at here doesn't bite on the idea that there can be concurrent entitlements, some reached independently through the independent right, and others via family members, and that there is an overlapping rule. What he seeks is to import Article 21, assimilate it to Article 11 to determine or to use it to override. But of course, the illustration of the grandparent carer and the two economically active parents in other member states shows you that wouldn't provide you with an answer as to who is the single competent state. And so the reasoning here, in my submission, is not persuasive on the correct construction of the relationship between Article 11 and Article 21.
Does he deal with Article 10?
Not in that. No.
Or does he deal with it at all?
No. And nor is there any detailed analysis of the rules, the express rules for prioritisation that we looked at before lunch.
Right. He does, so his reference to overlapping is simply, is confined to what he says about Article Recital 15 and 18.
In my submission, this is a quest for a kind of single legislative purity. It's not how the scheme works. Of course, there's a role given to the single competent state, the single state of legislation in Article 11 that's to apply. But there are also other ways in which entitlements may arise, and the overlapping rule deals with it. And this analysis doesn't engage with the full plenitude of the way the regulation works.
Thank you.
Perhaps this would be a good moment to look at ground three then, in terms of the previous regulation, and to look at how it was expressed. So the regulation itself is in tab 10 of the authorities bundle.
Can we go straight to Article 19?
Indeed. No, straight to Article 19. Now, of course, this is a regulation, as we already noted, that where the primary subjects are the employed or the self-employed persons. It's not an insured person. It relates to a time when it was only the economically active who were the primary subject. My Lord will see there in which the way in which the regulation is expressed. In Article 19 on page 67, there is the principal rule for the employed or self-employed persons in Article 1, and then in sub-Article 2, then the provisions of paragraph 1 shall apply by analogy to members of the family who reside in the territory of a member state other than the competent state insofar as they are not entitled to such benefits under the legislation of the state in whose territory they reside. So that's the bit, if you like, that doesn't make it over into the provision for cash benefits in Article 21, which we looked at. The only analogous provision that you find for a sort of priority rule is in respect of benefits in kind.
Those two.
Yes, exactly. And so the judge finds that to be of significance in the Upper Tribunal. We say that certainly means, and as the conciliation board say, that means that this provision in its analogous provision in Article 21 of the current regulation is no longer a conflict rule. It simply opens up the question of how entitlements may arise. It doesn't tell you which entitlement you can choose, but it tells you that there may be more than one. And then, of course, the control on that is Article 10. Yeah, exactly.
The other thing is, although you say the judge was wrong to rely on Article 19, it seems to me that there's another argument where you would want to rely on Article 19, in fact. And even if the judge is right and it's inherent in the rules that there should be one state, not two states, what 19.2 provided for was that family members would get it in the state of residence unless there wasn't such a provision in the state of residence, and then they could get it with the insured, with the family member's state.
Yes.
So the starting point there was that priority was for the family.
Yeah.
And the regulation, the new regulation, doesn't seek to change that. So was it intending to switch priority to the state of work of the family, head of the family, rather than the state of residence? And there's a way in which you could say, no, it didn't do that. It's preserved it.
Yes.
It's done it by a different route.
Yes.
11.3e
Yes,
is the bit that does that.
Yes.
And 21 is the bit that does it if you can't get it.
Precisely, yes.
Yeah. So, although you say that the judge was wrong not to use 19.2, your better ground is he was quite right to use 19.2, but he read it the wrong way.
And maybe infelicitous on our part, we say he's mobilised it for the wrong purpose, yes.
Well, in the wrong way, because that's what 19.2 did, wasn't it?
Yes.
It preserved, gave benefits, priority for state of residence for sickness benefits,
Yes.
And a residual pickup if you haven't got
Yes.
them. So you could then, if you were to read 11.3e and 21 together, you would start with, do you get it in the state of residence? Only if you don't,
Yes.
do you then switch to the Article 21 state?
Yes.
Or is that too
Yeah,
simplistic?
no, that's it, my lord, in a sense, because the sub-principles are
Let
now...
me make a note of that. So the old rule was sickness benefits, state of residence, absent that, family, head of family. And new rules, sickness benefits, residence 11.3e, in default, if there isn't any such thing, then you go to 21. So although it's not said it, if it's intended to reflect the position that there was before, you will get the benefit in one state and be your state of residence unless there isn't one, and then you can get it under Article 21. So there is a priority rule, it is implicit, but it's the reverse of the one that he said.
Yeah, well, yes, we would be absolutely...
In benefits, because they didn't switch the cash and benefits, the benefits in kind one.
Yes, yes, they kept...
They kept that. So why would they have changed this one and not said something about, look, we're changing this?
Well, the provision for... the provision for cash benefits now is regulated an interrelationship between 11.3e and Article 20.
So if the father's working in a state with more generous sickness benefits than England, the answer would be the child can't get those because it's the state of residence and there's a conflict rule.
The child, in her independent right, can't get that because the child is now a principal subject of the legislation as an insured.
And it's implicit that there is a conflict rule, but the conflict rule is state of residence unless in default, where there isn't any, you go to the state where the parent is working.
If the child applied if the father working in another country or economic parent in another country applied by reference to the child, then the overlapping benefit rule, if there were, would
No. There's no concurrent claim. There's one claim, but it's a claim in the state of residence.
Oh yes, my lord, yes.
I know you want concurrence. And
sorry, I misunderstood my lord.
Not concurrence, one, but state of residence one.
I misunderstood my lord's point. Yeah.
And it makes perfect sense because if you look at Article 19 is against a background where there is no concept of somebody having independent rights in an Article 11.3e scenario. That's why it makes a difference, because until the changes in the regs, you never had that. It always followed the person who's got the economic benefit. So now you've got people who've got rights in their own right, if you see what I mean, who might not be working.
Yes, the economically
Which will
inactive.
include, of course, family members, but is not confined to them.
Precisely, yes.
Then that you say, or there's an argument for saying, well, their rights are determined on where they are, unless for some reason they can't claim a right there, in which case you look to the rights of the person on whom they're dependent, wherever they happen to be.
Wherever it is.
Yeah.
So yes, that would be, that's how we get to...
One of the advantages of that, of course, is it then doesn't mean that it acts as an inhibition on the economically active member of the family from moving around Europe on the basis that if he just happens to go and work, or she happens to go and work in a state where they don't provide for the benefits, their disabled child is deprived of the benefits that they get from being here.
Which would be a disincentive to
Yes.
movement, yes.
So that's the logic behind it.
Yes,
You
so
would
it
say.
functions to allow the home continues in the home country, so to speak,
Yeah.
and the earnings can come from where you can find work,
Yeah.
which makes good sense.
Is it relevant, although perhaps it's not relevant, that the purpose of this benefit is to provide cash benefits for a child who's disabled, and it's much more likely that it's better if it's paid and used in the state where the child is, rather than it's not benefits in kind like hospital.
No.
It's cash benefits for a child who's disabled,
Whose needs
rather than the estranged parent. I'm not saying the father in this case isn't looking after the children, but I just wonder, it's a bit like child benefit, you put it in the pocket of the person who will
The level of
benefit from it.
is set by reference to the need in this jurisdiction.
I mean, so the child, of course, lives in this jurisdiction, and then the benefit is calculated by reference to the additional costs of meeting the need of the disabled child.
The needs of the child will be complex and will have to be met in a variety of ways. So the logic of it is for it to be this country.
Indeed.
You would say.
Yeah, yes, we said there's a logic to it. One can see how the system makes good sense.
Well, it would be logical to tie it to residence, because the purpose of the cash benefit is to focus on the needs in the state of residence, is the way to put it.
Yes.
Sorry, the purpose of the cash benefit is to focus on the needs in the state of residence.
Right, so where do we go now?
I think
We've done with ground 3.
we've done the ground 3, so I think
You've sort of voted ground 4.
yes, and so that leaves us with the conciliation. Just have a look at the opinion of the conciliation board, and insofar as one can draw anything from it.
Right.
It's a bit of a
You
carrot's egg from our point of view, because it
Well,
implies that
clear as
we
mud, I
assume it
think,
makes
isn't
good
it?
sense, and that's...
Well, they would say defeated. My colleagues have got two of the sharpest brains to my left and right, so maybe they'll help you. Let's have a look. Where is it?
So it's in page 143. Sorry, no, it's not.
Which bundle?
Tab 19, great.
The only nice thing is if they couldn't find the answer, you should at least be a bit kind to us if we can't either.
Okay.
So it starts at 146, and there are 11 pages of it. We can see the present. So there are the two states ahead on this. Obviously, not the appellant herself, but the interstate conciliation procedure,
Okay.
and where it's made under Article 6 of the referred to them under Article 6 of the implementing regulation. But you can see on page 148
There's Belgium's presentation.
Belgium's presentation, which inclines towards our position, and then you can see the United Kingdom's presentation on page 149.
Unsurprisingly,
Goes the other way, yes.
So can we go straight to the
The
analysis?
analysis we pick up on page 150. The first material passage for our purposes is on page 151 in the first proper
Full
paragraph.
It is clear.
It is clear, yeah. So they are focusing on the child's relationship to both of the parents.
Yes, because you both agreed it, but whether it's relevant, goodness only knows. Yeah.
Yeah. And then on the penultimate paragraph, you'll see they understood that the UK legislation confers an individual right to children. It's an independent right of the child, and therefore they define that having rehearsed that material, they then note that the dispute concerns two questions. The first of which is at the bottom of page 151, and the second at the top of the following page. And then you'll see top of page 152 under A, on this question of whether has primary competence. The reference to Title II being a complete and uniform system of conflict rules, which we've already seen that cited in the legislation in the Court of Justice and in Conavod in this court. And then in the second paragraph below, the title Primary Competence of Belgium. They'd understood that where there are priority rules, it's also common ground that, as stated by the UK delegation in this context, the overall scheme of regulation including Articles 32 and 68, prioritises rights based on economic activity over those based on residence. But then,
That's interesting.
in the final paragraph of on that page, the reference to the provision in Article 19 of the previous regulation is set out. And then if we look at page 100.
Sorry, is this? I don't think I understand this last paragraph. It is also true, as pointed out by the Belgian delegation, that 19.2 has not been completely retained. Article 19.1 provided that sickness benefits in kind should be provided on behalf of the competent institution by the institution of the place of residence. Is that right? And that cash benefit should be provided by the competent institution.
They're saying effectively that the qualifier, the insofar as, hasn't been carried over into the new regulation.
Don't let me detain you. I'll work it out later, or somebody will tell me. But I see. No, so it is still. Yeah, I see the problem. 19.2 doesn't have a competent state for the non-economically active by definition.
Mm.
Yeah.
And then in the second full paragraph up from the bottom on page 153, beginning as regards the export of cash benefits, we find the statement that the replacement article, Article 21 in the current regulation, is no longer a conflict rule.
Yeah. And I just realised the second paragraph on page 153 is what we were just debating.
Yes.
All
Yes,
there.
yes. Well, yes. So there's recognition that there is no longer a conflict rule, and then in the final proper paragraph on that page, beginning the conflict rule, notes that that a conflict rule is only preserved in respect of benefits in kind, which is of course Article 32.
That's the thing that may be questionable if, in fact, by a combination of 11.3 and Article 21, it's been preserved, albeit in a different form or
Yes,
a different way of expression. Yeah.
The structure is different.
It may actually preserve it. Yeah.
Yes, and they note at the bottom of the last two lines of 153, reading Article 21 as a rule always precludes the member state of residence from granting sickness benefits in cash, including in situations where there's only a fictitious right to receive a derived benefit from the state of employment, would be a significant, reading over the text, a significant change compared to the legal framework under Regulation 1408/71, a clear detriment to family members. And there's no suggestion in the recitals that there was an intention to narrow entitlement or to take away or to alter it in that way. And so their answer at the top of 154 is, in that first paragraph, is the Administrative Commission could consider adopting an interpretive decision taking into account that the rule under Regulation 1408/71 safeguarded the rights of family members. So one possible solution to this would be to have an interpretive decision from the Administrative Commission that effectively adopted the substance of 1408/71's benefit. Alternatively, an amendment, a legislative amendment to the regulation in those terms. And then in the second paragraph on page 154, they say...
So would the interpretive decision say Article 11.3e and 21 must be read in the same way that Article 19 previously?
Well, that would be one way.
Right. That's what they mean by interpretive decision.
Yes, that's my understanding. Yes.
What they
Theoretically mean, yes.
Yeah.
You might want to make them footnote 11. I think it's...
Yes. And then my attention is drawn to footnote 11. That
Oh, God. It's so small I can't even read it. Even though
I know, I
I
just had to found it. Maybe we just take a moment to read it. Me reading it.
basically says we cocked up.
Well, basically, they didn't think about it.
Yeah.
Yeah.
Yes, it's the sin of omission.
They didn't think about it. They thought they were going to amend the rules within a mobility package, but it hasn't happened.
Yes.
Well, look at the end. Some member states accept the wording provides a choice, and others say the gap can be closed by interpretation. Oh, right. Okay.
We're not getting a single way out through this.
Nobody's referred this to the CJAU. I know we can't, but nobody else has.
No one else
This
has
provision.
BCB.
And then we get to the second paragraph.
Exactly, where they then say
There's another alternative.
there's another way of doing this, which is to go through the Article 32,
Yeah.
the more detail. So if you were legislating to amend, you could go through the Article 19 route or via Article. So what they say in the final paragraph of there is that Belgium could, not should, could be regarded in circumstances as the competent state in accordance with Article 21. If the rules contained in Article 19 of 1408/71 are no longer applied. So if they are no longer applied.
So option one is apply the rules or interpret the regulations as if the rules still applied. In other words, consistently with the old regulation. Option two, if that doesn't apply, treat Belgium as the competent state, but then ask whether or not it stops an overlap.
Yes, indeed.
Concurrent rights.
Yes.
So then the conclusion, or was it this,
The conclusion on this issue is not
you
really.
agree with the conclusion, as it were. You agree with the outcome, but not the way they've got there.
Well, this reasoning suggests there are a number of there's no lacuna. It's an oversight, and there are different ways of solving it.
Is there what aspect of the analysis that you conducted before us this morning is omitted from the board's consideration? There's no reference to Article 10.
There is later on
They do talk about overlapping rights.
in the next section on the principle of the application of the legislation. So little b, the second question, begins as the last line of on page 154, and then And then my Lord will see on the second paragraph on 155 that it has settled case law of the CJAU confirmed in numerous rulings that the principle of application of the legislation of only one single member state in the matters of social security means in practice that the persons covered by the legislation of a specific state will have to pay social security contributions or other levies allocated specifically and directly to financing social security only in that state. So it's about single state principle is effectively starts first bites in that context. That you only have to pay in one state. But the next paragraph is...
Yeah, the next paragraph's the important one from your perspective. Yeah. It's making the same point that you made to us this morning, which is that principle doesn't preclude there being simultaneous entitlement to benefits. And you pointed to the proviso and said that's what the proviso is all about.
Yes, and this paragraph is consistent with our submission.
Yes, it is.
Yes, it is actually.
And so I won't read it all out, but
It's the final sentence, actually. The principle of a single applicable legislation doesn't mean that the grant of a benefit alone renders the legislation of the member state whose institution is granted that benefit the only applicable legislation to that person.
Yes. And then, and you can see how they then yoke it to the jurisprudence of the Court of Justice.
Well, they're making my Lord Justice Baker's point, which is the disincentive to the family member to move around the EU if you take away in the rights of his family members.
Indeed, my Lord, yes. It's and so.
I'm not sure that they're fairly attributing or describing them recital 18A actually. That there are two things: priority of residence or concurrence. And I can understand the first 5 lines because there you've got different benefits from different periods, but I don't think that really helps this case.
No.
And then you go on to the second half, and that takes the words of the caveat that you rely on, and I understand that.
Yes.
But then it says, accordingly, as stated in recital 18A, the principle of single applicable legislation does not mean that the grant of the benefit alone renders the legislation of the member states whose institutions grant the benefit the only applicable legislation. I don't think 18A is saying that. It seems to be saying the opposite.
I mean, this is not a particularly consistent piece of work.
Yeah.
It has, I don't seek to say it's our submission.
No, but the middle bit is consistent with your submission.
It is, yes. But that part, we don't need it. And then, so the final paragraph on that page obviously deals with how this all yokes together to the aims of furthering free movement objectives. And then then you'll see the reference. We discussed whether or not a moment ago whether there was a reference to overlapping benefits. And you see that in the first 2 paragraphs at the top of the following page. And there is discussion of the various provisions.
There's Article 10.
Yes, my Lord, yes, it has. The general provision, if you haven't got it from anywhere else, from Article 68 or from Articles 53 to 55 and so on, then you always have Article 10.
Right.
My Lord, I mean, you see just to complete, you see the conclusions at the bottom of the page. My Lord, those are our submissions.
Thank you very much, Mr. Perry, for tolerating our interruptions and for your helpful submissions. So, Mr. Lemay, you're going next, I think.
I am, my Lord. My Lord, you opened with a pretty on-the-money observation about how difficult this case is.
Very difficult.
Social security cases are always difficult because the structure of social security law is very often a kind of regime of splat the rat. You have to trace changes through the legislative history, and that's true of Regulation 1408, which went through any number of changes, which are all then carried over into Regulation 883, which has been changed. It's true of domestic law as well. And that's why this case is so very dense. It's like some kind of fever dream viva voce on social security law. But our case can be put very shortly, notwithstanding that. We say, first and foremost, and very much as our primary argument, that this is a case where there are, in fact, 3 people in a family and 3 separate entitlements, because there are 3, and I know I'm throwing down the gauntlet to my Lord Justice Lewis, there are 3 insured persons in their own right. Now, multiple insured persons in relation to sickness benefits is likely to be a very rare circumstance for reasons I will explain, but they principally lie in the fact that most sickness benefits are contributory, and it's going to be a very rare circumstance indeed that children have made contributions, particularly under the age of 16, sufficient to entitle them to a sickness benefit. All of the peculiarity and difficulty in this case ultimately stems from the assimilation of what were the old supposed special non-contributory benefits, which effectively gave rise to an entitlement simply by dint of residence, into the sickness benefit regime, and added to that the complication that arises from the fact that, quite exceptionally, a benefit of this kind is created in the name of the child in their own right. And it's those features that generate the quite unusual circumstances of this case of the types of multiple insured persons that are in play.
What was the first feature? The benefit in the name of the child is the second. What was the first?
The first is that the problem we're dealing with is the structure of UK sickness benefits, which are non-contributory rather than contributory, and they have their origin in the old special non-contributory benefits, which were intended and designed to be payable only in the UK to meet the special costs and needs of the recipients in the UK. They were designed for things like care, attendance, disability living allowance, mobility, and care component. They were all intended to provide for the extra costs of assimilating those particular affected people in the United Kingdom. That was their purpose. And that's not what conventional sickness benefits are at all. Conventional sickness benefits in cash are akin to our statutory sick pay, except paid by the state rather than the employer.
Income.
Yeah, they replace income lost during a period of illness. So that's the source of the complexity in this case. And it's very important to understand it and to understand why it is that the Secretary of State's analysis, accepted by the Upper Tribunal, is so very ambitious. Because there, in general terms, isn't the need for the type of priority rule that's said to be implied into Article 21. There aren't generally problems of concurrence, because generally there aren't multiple insured persons. And the reason there aren't multiple insured persons is that generally there's only 1 or maximum 2 people who are making contributions. And any time you have 2 people making their own contributions, they're necessarily all in an Article 3A scenario. Now, once you do have that very rare scenario of multiple concurrency, that is enough for entitlement under the domestic regime. Because all that Section 72(7)(b) says is that the UK is a competent state. Not the only competent state, it just has to be a competent state. If there are 3 competent states, because there are 3 family members, and one of them is the UK, that is enough to get home. Now, the only answer to that, and bear in mind, Section 72(7)(b) was designed by the UK to be, in effect, a rule to prevent multiple benefits being claimed. The only answer to that is that there is a priority rule embedded in Article 21. And it's that reasoning which is the kernel of the Upper Tribunal's decision at 32 to 36. And that's the reasoning that has to be confronted. But properly understood, we say Article 21 is simply a rule for providing a minimum entitlement of a derived right to sickness benefit for family members, whether or not they are insured persons. That's all it is. It's not a rule that preempts or precludes other rights from arising. That it's not a rule of priority, we say, is evident from a compare and contrast with the other provisions in the regulations that are priority rules. Rules like Article 32 and 68, which you've been taken through. They say in terms they're priority rules, and when there is a priority rule, it means this and only this is the source of the entitlement to the benefit in question. Equally, we know that Article 21 is not an overlapping benefits rule. because you've got examples of those too. Provisions like Article 34 and Articles 53 to 55 set out rules that operate in circumstances where there are, potentially even in relation to one single applicant, overlapping entitlements. Now, the very fact that the regulation contains both priority rules and overlapping benefit rules is proof positive of the impossible ambition of the submission that all along there has been embedded in Article 11.3e. That's where the Upper Tribunal's reasoning actually ends up. It's not in Article 21, it's actually paragraph 36 of the judgment that says, well, actually, the answer to all of this is that there's an implied priority in favour of the Article 11.3a worker rights. If that were the case, there wouldn't be the need for any of the express priority rules or the overlapping benefit rules. And it's evidently a conclusion that proves far too much. So what we have in Article 21 is simply a provision designed to create a further derivative right. And that is wholly beneficial from a free movement perspective. If it means that there is a multiplicity of options, it's pro-free movement. If the government doesn't like the fact that there are overlapping benefits in relation to another state, whether it's by reference to derivative rights or otherwise, their solution is to introduce overlapping benefits rules, which they are entirely free to do. In other words,
take away their own national rules. For such
absolutely. But the answer to that is not to distort the scheme of the EU legislation, which is a regime of coordination. It is for the government to recalibrate the terms of the overlapping benefit rules it employs, which is why, ultimately, the terms of Section 72(7)(b), which no one suggests constitute a bar in this case, other than by reference to the importation of the regulation. They don't constitute a bar, a domestic bar. That's why they're so very important.
Does that mean that the insured person has a free choice between the two benefits?
It does. You have a free choice subject to any rules of priority that are contained in the regulation, subject to any overlapping benefit rules contained in the regulation.
You say there are none.
There are none here. Subject to any overlapping benefit rules, there are none here in this case.
What about Article 10?
Article 10 is a general overlapping benefit rule.
Where there isn't a specific.
Yes. In circumstances where the dual entitlement arises from the same period of contribution. And that's the critical wording in Article 10.
Yeah.
What it's designed to do is to stop a worker, Mr. A, Mrs. A, from saying for the period X to Y, I am entitled in the UK for X to Y to generate this benefit, and in France for the period X to Y to derive.
So it doesn't apply to a non-contributory right?
Absolutely, because it's not reliance upon the same period of contribution.
Right.
So it is a general rule. It will bite in many cases, but it doesn't bite here when the relevant period of contribution is quite different. And that's why my Lord Justice Baker's point this morning that it's significant that it's only the same person for the applied benefit rule is important, because obviously the minute you're talking about Mr. H, he's got his periods of contribution, and the minute you're talking about AH, she has a completely different period of relevant residence, which is the relevant residence required to meet the HRT test. They're not the same period, and that means there is no overlapping benefit rule.
So it's the same period of compulsory insurance equals the period during which you make contributions. Therefore, there must be contributions.
Yes, and it's an.
Those are the words that do that.
Yeah, those are the critical words in Article 10. And once you understand Article 10 in that way, you appreciate the overlapping benefit rule it applies doesn't operate in these circumstances. That then leaves in the hierarchy the last choice being a domestic overlapping benefit rule, and there is none. And that being so, AH is entitled to the benefit. Now, if you're against us on all of that, and I very much hope you're not, but if you are, and there is some need to engage in some exercise of prioritisation between the three rights, which we strongly doubt, and if you're with me that the answer to that exercise in prioritisation is not provided by either Article 21 or 11, as we strongly suggest it is not, then we do say, in those circumstances, the priority should be set, first of all, with the best interest of the child in mind, as is required by Article 24.2 of the Charter of Fundamental Rights, Article 3.1 of the Convention of the Rights of the Child, and Article 7 of the UN Charter on the Rights of Persons with Disabilities.
Well, to what extent are we entitled to take those
Well, you are.
provisions into account?
The Charter binds because we're dealing with a period of membership in the EU, so it would be binding. This is the field of application of EU law for the purposes of Article 50 because we're dealing with a period before the 1st of January 2021. And both the Charter of the Rights of the Child and the UN Charter are the types of sources that are regularly drawn upon by the CJEU when engaged in this sort of interpretive exercise. The critical thing to note about Article 24, when we come to it, of the Charter, is it actually contains a second dimension, which is beyond best interests. And maybe now is actually a convenient point to mention it. It's in the authorities bundle at page 161. Now, I apprehend my Lord Justice Baker is a good deal more familiar with than I am with these instruments, probably having seen them many, many times before. But the Charter,
Page
161 of the authorities bundle, the Charter reiterates the standard international law obligation and domestic law obligation to treat the child's interest as a primary consideration. That's the second limb. But where it's distinct from the other instruments is 24.1. Children have the right to such protection and care as is necessary for their well-being. And the whole point about DLA, care component, is that it's designed to provide the level of care appropriate for the well-being of a child with a disability.
Not just a child, though.
Up to 16. After 16, you're into the terrain of a different benefit, PIPs, and the enhancement to universal credit. So the peculiarity, DLA used to be a benefit much more widely available, but now it's a legacy benefit effectively only available to those who are 16 and under.
I'm having trouble in reading children shall have the right to such protection and care as is necessary for their well-being as telling me that prioritisation, I think you're going to say, state of residence.
It supports the points my Lord Justice Lewis was making earlier, which is that if you had to pick one, the obvious choice would be the state of residence of the child. That's the place the child is living and has their relevant care needs. That's the place that generates the costs. It's the relevant cost of living. It's the relevant calibration for their needs. And that's the obvious starting point, therefore, for calibrating the benefit that they in fact need. Let's give an extreme example. Suppose the cost of living in one member state is X, and in another member state it's 4X, and the child is residing in the state that's 4X, and their parent is working in the state that's X. It's obviously unsatisfactory if they're being provided with a level of care that is unable to meet the costs of their living in the state in which they are actually resident. And that's why we say these instruments point in our very much secondary argument.
Rewinding a bit, the start point here is you've lost, and we're on to argument 2. You need a rule of prioritisation. We are against you, and we say it's inherent in the opening words of 11.1, or it's inherent in the structure of the regulations.
That's right.
And then we've got to pick which priority it is. Is it state
Yes.
of residence, or is it state of
Yes,
the
correct.
economic active person? And so you're just saying that these are international reasons why we must pick the state of residence. And it would be the same if it was Belgium. The child was in Belgium.
Correct.
And the father was here. Of course, applying the children shall have the right to such protection and care as necessary, they wouldn't get anything in Belgium because the rule in Belgium wouldn't say it. But you would say that doesn't matter because they can't need it in Belgium if Belgium doesn't provide it.
Well, correct. And the reality may be, in any event, that in Belgium, and indeed many other member states, these needs are not met
They're met by other
benefits.
means.
They're met by social assistance.
Yeah.
Now, my lady may know the important distinction between social security and social assistance. This only coordinates social security. And very often, these types of needs for these types of individuals will be met by discretionary schemes of social assistance.
But if it's, I'm still worried about using, we haven't got beyond the Charter, I'm worried about using the Charter. So I'm using the Charter to interpret what? Article 11.1 and 11.3e. That's what I'm doing at the moment. I'm saying 11.1 and 11.3e must mean this, priority and state of residence, because otherwise any rule other than priority would be contrary to Article 24. Is that it?
That is the argument.
That is the argument.
It is very much the second tier argument, because we do say that the first tier...
No, I understand that, but we're into that. You don't need to keep repeating this a second.
I'm so sorry.
We won't forget. I promise you we won't forget.
Okay.
So, any other interpretation not based on residence would lead to a conflict with Article 14.
Yes, and of course that approach has the added benefit that you're necessarily...
Hold on. Any other interpretation not based on priority for state of residence would lead to conflict with Article 24.
Yeah. It has the added benefit by picking on residence that in most cases, save for my Lord's grandparents example, you are also choosing the state of the parent who has care of the child. And insofar as these benefits are paid...
Well, assuming that the child's not living with the parent who is carrying out the economic activity in another country. You've got to assume that the child is living in a different member state from the economically active parent.
Absolutely, but what that removes is the risk of a payment being made to someone who might be, I'm not suggesting on the facts of this case, it's true, might be estranged, might not be motivated to make a claim for the benefit, might not be motivated to pay over the benefit they receive for the actual care of their child. So you're, by that dint, you are ensuring to a far higher degree the likelihood of the payments in question actually redounding to the benefit of the child in question.
And have you got any authority at all that says a national court or the CJEU interpreting the provisions of a European Union regulation must have regard to Article 24 when interpreting or implying provisions into that regulation?
The Charter is a general source of interpretive principle for all EU secondary legislation.
Right, and so it won't be difficult for you to find an authority.
We'll find one overnight.
For
sure, my lord. It's just like using the Human Rights Act to purposively construe...
I don't, you see. I read you section 3, and that says, I find out what it says in English first, and then if I can twist it, I do. But I don't like statements, I like...
Well, we'll find a case.
I mean, your point is that as we're dealing with a EU case, we don't have to worry about what the Supreme Court has said recently about the use of unincorporated instruments.
The CJEU regularly uses international instruments to interpret EU instruments. It does so with much greater freedom than the Supreme Court.
But with a certain degree of caution as well.
Yeah. And you've put two authorities in that deals with validity of community things, and you will, I imagine, say that international conventions that are relevant to interpretation as well as validity.
Correct.
And I'm sure you're right to say with astonishment that Article 24 is obvious. It'd be quite nice to have something that shows us how it goes.
It might not be in relation to Article 24 itself. It might be in relation to another charter, right?
Doesn't matter.
I'd
just like to know.
Mr. Meta's on it.
It would be very nice to find one with Article 24.
We'll do our best to do that. That would obviously be the bullseye.
Because it's a very, very broad, children should have the right to such protection and care as is necessary. To translate that into a rule that says you must interpret a scheme in one way rather than another. It's a huge request to make.
Well, particularly when you've got a scheme which specifically, when it deals with prioritisation, says that top priority goes to the place of economic activity and bottom place goes to the right to residence. And so it does fly in the face of the overall scheme to say that you can somehow trump that by referring to Article 24.
Well, with respect, my lady, we don't accept that simply because Article 3A comes numerically before 3E, that there is any such inherent prioritisation between the different sources of applicable legislation. That, with respect, doesn't follow. And were that to follow, that would be saying that Article 11.3 contained in all circumstances its own internal prioritisation rule, as between parties in a family unit, rather than as between the same individual. That's the difference. Obviously, if you're looking at just one person,
Yes.
there is a priority rule. But if you're looking at a family unit, there's no relative prioritisation of the quality of any particular right, whether gathered by A through to...
Well, this is back to your point that it's
Yeah.
very unusual to have multiple
It is.
insured persons.
It is. Now, I suppose I should, at this point, meet the glove that has been very firmly thrown down by my Lord Justice Lewis about the status of Mrs Harrington. The reason why Mrs Harrington herself is an insured person in our submission is because the test for an insured person is not by reference to the specific benefit. It is by reference to whether or not the person is insured for the purpose of the relevant chapter. And Mrs Harrington is herself insured for the relevant chapter because she has exactly the same habitual residence.
And you've got to show me that, actually. To prove.
Certainly.
This is what I was asking you about. You can get different competent states for different benefits. With the Cyprus case, they got one for the state for the pension, another for the carer's allowance, and so on.
Yes.
That's what I was asking.
It's
but if you say it's not as simple as that, benefit by benefit, but group by group, you need to talk us through that.
Absolutely. So page 76 of the authorities Bible,
Yeah.
the definition of an insured person. It means any person satisfying the conditions required under the legislation of the member state competent under Title II to have the right to benefits, taking into account the provision of this regulation.
So you've got to first of all identify the member state competent under Title II.
Yes, but it's easiest and most convenient to test it by reference, let's say, to Mr. Harrington, and then we'll extend it to Mrs. Harrington. Mr. Harrington, why is he an insured person for the purposes of Belgium? Because he has been paying his contributions in Belgium. And because of that, should he become sick, which he is not presently, he will be entitled to such sickness payments as Belgian law entitles him to.
Well, that's because just working it through, Article 11, he is a person pursuing an activity as an employed person in a member state. So he's subject to the legislation of that member state, which is Belgium.
Correct?
That is therefore the member state competent under Title II.
Correct?
And if he satisfies the conditions required under the legislation of that member state, he is an insured person.
Correct.
Yeah.
And it's no answer to that
Not
analysis.
to be pedantic about it.
No,
but
no.
That's the right exercise.
Exact, I think, is the right word,
Yeah.
my lady.
I'm not saying Mrs.
Pedantic.
Harrington is not an insured person, but it doesn't help the child to get a right to the care component of disability living allowance, because she's an insured person for some purposes, but that doesn't give the child the right to a derivative claim for some different benefit.
No, but the
That's all.
point is,
Oh,
once Mrs. Harrington is herself an insured person, and the facts seem to establish that she applied for carer's allowance,
Yes.
she's caring her daughter, the reason she was refused is that there is an equivalent provision to 72(7)(b) in relation to carer's allowances. She was refused on the basis that her husband's place of work was the relevant state, so she was refused carer's allowance, but she didn't pursue an appeal. And the reason she didn't pursue an appeal appears to be the difference between her case and that of the daughter is that DLA was in payment. And the reason the case started was a dispute about whether or not the DLA that had been paid over should be repaid or not. Mrs. Harrington didn't pursue her appeal, which would have been on exactly the same grounds.
Assume you'll tell me it would work for other reasons, but I'm trying to be helpful and to put it into practical terms, so bear with me and don't just pick up on trivial points. Assuming she's pregnant and she's entitled to pregnancy benefits or maternity benefits or all sorts of social benefits that are paid to pregnant women. Marvellous. She's an insured person. She can go down to the office and pick up her benefits. That wouldn't give her child a derivative right to a different benefit. And all I've been trying to say is I don't understand why we have to introduce the mother into the equation of care component, because the child in one analysis has it, she may have it through the father, and the question is, do we have to have a priority rule, and if so, which one? So I just find it unnecessarily diversionary to discuss Mrs Harrington's state.
Let me make one last effort to answer my daughter's point. Once you've accepted that for this pregnancy benefit, Ms Harrington is an insured person, you then go to Article 21. And the point is, you do the Article 21 exercise for 3 individuals.
Yes.
But she's not an insured person living other than in the competent state.
Yes, and that's the answer to why in her circumstances you don't get into Article 21. But it's nevertheless the fact that you have to, for each person, ask the relevant questions in the relevant places in relation to Article 11 and Article 21.
In what sense then does the appellant derive a benefit or right to benefit from another?
She doesn't on these facts.
On the facts?
No, but she's still, and it's important.
So, I still think
yeah, well,
the Lord is banging his head against.
I'm going to stop.
I can't see what she's going to get. I don't care what her mother gets. The one thing she doesn't get and can't get is care component, the DLA, and that's it. Why does the child get it?
Why does it matter? Why does it? I mean, given that she can't on these facts, why does it? Why are you pressing the point?
No, I'm going to stop. I'm going to stop.
No. Is there some underlying reason, bearing in mind that our decision may have ramifications beyond the facts of this case? Is there some underlying reason why you would like us to pronounce in favour of your proposition when it doesn't apply to the facts of this case?
Exactitude as to when you have independent and derived rights is important under the withdrawal agreement. And I want to get into the details of that because we're all agreed on the facts of this case that there is no power to refer here.
What I am anxious to do is to avoid us inadvertently saying something which is going to...
Maybe I should show you
particularly under the withdrawal agreement.
Maybe I should show you the relevant provisions of the withdrawal agreement because they're going to feed into what I say on the topic of
just a moment.
Reference.
So the withdrawal agreement you wanted us to go to?
Yes, madam.
Okay. Could I say, Mr. the Mayor, we're unlikely to get enticed into...
I'm not asking you to.
Into saying anything about the withdrawal agreement. What I'm reluctant to do is not saying something inadvertently.
That's right.
That fouls the water further downstream.
Absolutely. All this submission is, here be dragons, and I should show you what the dragons are.
Yes.
So
page 171?
It's page 172.
Yeah.
172 is the rule as to coverage, and it borrows very heavily upon the terminology of Regulation 883. You will see that there is the same language of legislation, an individual being subject to legislation, and then there's the same language of family members and survivors.
So where are you exactly?
We're looking at the various criteria 31A to G, which are the circumstances in which the withdrawal agreement will apply to you. And you have to ask the question for a union citizen or a UK national whether they fall into one of these things. If they do, there are then derived rights in each circumstances for as well as...
So a sentence saying we're only dealing with the position out of the 2015, not the withdrawal agreement, is the end of the argument. We've saved anybody losing anything for the future.
Yes. The possibility is this, my lord, that the dispute in this case, that can't be referred. And let's be honest about it. This case would be about as strong a nailed-on case for a reference.
Yeah, but Parliament has said we can't, so that's the end of that one.
Correct. But the point that would be referable in this case, were it capable of reference, will reoccur, or will be likely to reoccur.
So we can't refer, and if we say we're only dealing 2015, not the agreement, then we needn't worry. Somebody else can worry about it. It's complicated enough without thinking.
It is. And what I was going to invite the court to do was to make this observation, that had you had the power to make a reference, which you don't, this would have been a case in which you would have or would have strongly considered so doing. So that,
the purpose of that?
So that, as and when...
It gives you a leg up when you get the right case under the withdrawal agreement.
Absolutely. As and when the point reoccurs before the first-tier tribunal or the upper tribunal, or wherever it may be, the question of referability is approached on that basis.
Well, for my part, at the moment, I think it would be better for an argument for a reference on another case should be decided on its own merits rather than the near miss on this occasion. But I may don't know how to think about it. That's the point I wanted to flag. Now, as to section 72(7)(b), I promised I'd explain the genesis of that, and it is a matter of some importance. The short history is really this, that there was this category of a benefit called a special non-contributory benefit, which was non-exportable. In other words, DLA and all the other benefits that were listed in the old annexes to the Regulation 1408 were only payable to people who were resident in the UK. The listing in that annex and the status of the benefits as special non-contributory benefits was challenged by the Commission in infraction proceedings in a case called Commission in the UK, which is referenced in the Upper Tribunal's judgment. And in consequence of that, those benefits were pulled out of the old SNCB category and categorised as sickness benefits. The UK had to react to that, and it did so by doing two things. Firstly, by saying you weren't debarred from claiming DLA care component, attendance allowance, carers allowance, all the sickness benefits we've been talking about, by dint of the fact that you weren't resident in the UK. So that was the give. And the takeaway was section 72(7)(b), which said you won't be entitled to receive these benefits if another member state is the competent member state. Now, the explanatory memorandum that accompanies the regulations makes it quite plain that this was intended to be, in effect, a species of overlapping benefit rule. To prevent a situation where, let's say, for the sake of argument, I lived in Northern Ireland and I worked in the Republic of Ireland. By dint of my work in the Republic of Ireland, I got one sickness benefit, but because I was residing in Northern Ireland, I got DLA, or its equivalents, in the Northern Irish system. And as an overlapping benefit rule in circumstances where there is one claimant, it works perfectly well. The problem is the problem that the legislature has never grappled with, the fact that derived rights also exist under the scheme of the regulation. And the legislative overlapping benefit rule has never addressed the question of what to do in circumstances like this case. It explains, if you like, the silence that has generated the particular problem that we face now. That's the first significance. The second significance is it explains why it is that it's the UK, and this type of case in particular, that is the engine for these types of problems. Because we have these sorts of benefits and no one else does. Interesting.
Apart from apparently Portugal.
I don't think Portugal has. Yeah, the Portuguese healthcare system works on that basis, but I don't think their sickness benefits do. I think the only...
Ireland and Cyprus and Malta, they don't.
Yeah.
Or I don't know, I've picked three countries that have...
Yeah, my understanding is it's basically the UK.
Okay.
That was certainly always my previous understanding. And so when you come to approach Article 21, you have to understand that it's a provision that was designed essentially for contributory benefits. Once you understand that, Article 21, and can we, at the risk of boring the pants off you, go back to it very briefly. Article 21 makes much more sense because the first sentence of Article 21, the one we've been poring over, is really no more than a specific enunciation of the same principle that you find in Article 7. Article 7, we looked at earlier, that's at page 86, the waiver of residence rules. Article 21 is really doing no more than the same thing and saying where there is a competent state in relation to an insured person, the fact that the individual in question is not residing in the competent state doesn't debar you or your family members from entitlement. It's exactly the same as Article 7. The reason that we've got Article 21 is the rest of what it does. The rest of what it does is to then go on to say, well, that arrangement can be displaced by agreement. That's the first paragraph. And then it goes on to explain how this will actually operate in relation to the complexities that may arise from calculating incomes if they're relevant to the replacement income benefit and contributions and matters of that kind.
In other words, it adds practical flesh as to how this type of scheme is intended to work. But what it is not, on its face or on its substance, is a rule of priority.
I understand that, but we still have to, I mean, although Article 21 is designed to deal with contributory benefits, and many of these are,
Yeah.
the fact of the matter is, we've got to shoehorn what we've got into this structure. And if you had a father working in England and the child in France, the child in Belgium, there would be the same arguments as to if it was concurrent rather than a priority rule. You wouldn't want to disadvantage the child in France under Article 21 if, in fact, it was a concurrent choice thing and they wanted to get the ones from England.
Well, that, with respect, is the answer to the question my Lord sort of threw down and said, isn't the problem with interpreting and as being only and as opposed to and or, that it will produce unintended consequences in other circumstances?
Yeah.
And my answer to that is this. If Article 21 is not a rule of priority at all, then there is no problem in interpreting the word as and or. And that would accord fully with Article 7. Would be doing exactly the same thing as Article 7 and all the case law that my learned friend Miss Ward cites, Pinner, etc., that say in general terms you can disapply residence bars of that kind where your families are living back in your home country as opposed to your country of work.
There would be a saving rule. It would be saying just because you or one of your family members has gone abroad, that doesn't stop you getting it.
And that's
it's a removal of a barrier.
Exactly, my lord.
Yeah.
In other words, you are enabling a multiplicity of claim because they might be able to claim in the competent state, they might be able to claim in the state of residence, subject to any rules in the EU regime or the domestic regime to deal with overlapping benefits. That's pro-free movement. Yeah. But if you interpret Article 21 as a rule of priority, then we would suggest you are taking something away. You are taking away the choice. You are generating the situation where you may have the very type of anomalous lacuna that is presented in this case, where there is no entitlement at all. That's very hard cheese, and there's no...
contrary, you would say, to the underlying principles of free movement, which are the raison
Absolutely.
d'etre for this regulation.
So the minute you approach Article 21 as if it is a rule of priority, then the free movement considerations require you to interpret and strictly, such that there will only be a rule of priority taking away concurrent entitlements if both the insured person and the members of the family are outside the competent state. Yes. That's my submission in relation to that. And that, with respect, is a principled submission that seeks to give effect to the free movement objectives of the regulation, depending on how you characterise Article 21.
If what I put to Mr. Berry earlier is correct, and that the position previously was cash sickness benefits for family members' state of residence unless they're not available in default of the economically active parent state. If that was what the position was before, and if I think that that's what this regulation is intended to preserve, and it does that by 11.3e, by saying family members effectively who aren't economically active get that, but there's got to be a rule of priority for them getting both the residents and the non-residents. Can I interpret Rule 21 in a way that's consistent with that, or is it all a red herring to Article 21?
It is in my submission a red herring. Where you get to with that argument, I think, is this, that the old rule that sought to guarantee a multiplicity of options with a preference for the state of residence, for all the purposive reasons you identified, that's the best place to pay these types of benefits to these types of people, is replaced by a system in which entitlement is linked to being an insured person rather than an employed person. And by dint of that factor, you get the same multiplicity, albeit without the default rule being the state of residence expressly articulated. You get it through Articles 3A and 3E. So you arrive at the same place.
11
11
and 3A.
3A, 3.
just put it ready to help me in this way. If Belgium did have a system of cash benefits, sickness cash benefits, if it did have, and it was €100 per child, and we had £20 per child, and I believe that Article 19.2 had been transposed in, and there should be a rule. It's the state of residence. It looks very little, £20, but it's cheaper living here than Germany or whatever. So it's £20. How do I, in inverted commas, stop you making concurrent claims and have a single state claim, which is based on state of residence?
Well,
what's the mechanism and that you wouldn't want it, but what would I, if I was being really mean, want?
I think that takes you into a historical argument about Regulation 1408 that was never made. And I think it would take you into an argument as to whether or not the terms, page 67 of the authorities bundle, insofar as they are not entitled to such benefits under the legislation of the territory in whose territory they reside, debarred you from making any claim in Belgium, or any claim in Belgium that was effectively double recovery.
That's what it seems to say.
That would be my submission, but that would be the debate. But what would not be...
Assuming I'm right, then, just assume for the moment I am right. And this means if you're a family member, you get it in your state of residence unless there isn't one, and then you get it in the economically active state. Assume I'm right. What's the answer to the question I asked a few months ago? How do I stop them getting it now under Article 21 in Belgium when they're resident in England?
Well,
what's the mechanism under the new regulation?
Under the new regulation, I don't think that there is a mechanism.
So they do have concurrent claims?
They do have concurrent claims, and that is the material change between the two, subject to any national rules preventing overlapping benefits.
But so they do have concurrent claims, and that was a conscious switch by the union legislature, or an inadvertent switch, but it is a switch, it's a change.
I think, having seen the contents of the conciliation boards, I think we can say it was an unconscious switch.
It's an inadvertent expansion.
Yes.
From single state of residence claims to concurrent claims.
Yes. But with
the rule of priority.
With respect, it is inadvertent, but it's also an unreal problem, as the facts of this case illustrate, because there are going to be no circumstances in which someone can make a claim for a benefit of this kind in other member states.
Right, so it's an inadvertent expansion from a rule providing for a single state of residence having priority to concurrent claims with no rule of priority.
Well,
that's your submission, though. No?
The old rule of priority was not an absolute rule of priority.
No, never mind that. Don't distract. Answer the question. Am I right to write down the words? It's an inadvertent expansion from a single state of residence to concurrent claims with no rule of priority on your submission.
Well,
I think the answer is yes.
I think the answer is yes. Yeah, I think the answer is yes. But and I don't want to antagonise my lord by making the point again. The important point is that the old rule was not an absolute rule.
No, I've understood that, and I've moved on.
Okay, well, then.
And I told you to work on a hypothesis.
Yes.
And you ignored that, and you've gone back.
I haven't ignored
the answer is yes. I think that's what you say is happening.
Yes.
Yep, we got it. All right, got it.
Right now, Mr. Donnell, I think we've got to that point. Where do we go now?
So, can we then very briefly look at the tribunal's reasoning, which I want to address with those principles in mind. We looked at it with Mr. Berry briefly. Be extremely quick. I just want to canter through the key paragraphs in 32, page 53 of the core bundle. We have the fact that the key reasoning is that there is an implied rule or an express rule of priority in Article 21. That's the battleground, 32. Mr. Berry has answered the point in relation to 11.1. There's no meat in 11.1 that's relevant here because there is a single source of legislation applicable to each person, and that rule is not being displaced. So that doesn't answer the question. We've been through the Article 19 as was 21 comparison just now, so that is answered. It's said at 35 that this interpretation does not hamper free movement, but for the reasons I've just explained, it does. A priority rule that removes choice and leaves potential lacunae is a bar to free movement. So with respect, that is wrong. And then lastly, at 36, we have this important passage, which is worth just briefly looking at. He says, haven't I said that an insured person is wider than that? It's true that on my interpretation, insured person may be economically inactive In that case, the legislation to which the person is subject is 11.3e, so it accepts the legislation is applicable, but the design of Article 11 is to give priority to the place where the person is pursuing activity as a self-employed person, as the opening words of Article 11.3e make clear. So what he's actually saying is that the real source of the rule of priority is in Article 11, not Article 21. And you have my point that that reasoning is impossible to reconcile with the express priority rules and the express overlapping benefit rules and the general overlapping benefit rule in Article 10. It's obviously wrong with respect.
It's also very difficult to reconcile with the language of 11.
It is, my lady.
That's the basic point, because 11A is dealing with one scenario and 11E is dealing with a completely different scenario. It's nothing to do with priority at all.
Absolutely. So that's why we say, and we very much put our eggs in the primary basket, there's a multiplicity of entitlements, there's an entitlement to choose, that's enough to get you within 72(7)b, and that's that. You have the gist of my submission in relation to the alternative argument. I don't see any basis for a suggestion that you have to find a single prioritised system of legislation. As my learned friend explained earlier today, that's just not the scheme of the regulation. But if you do, then the international instruments I pointed to suggest that the one you must choose is the one of the place of the resident of the child and the likely place of the resident of the parent with care. And that is what does the best by the interests of the child in those circumstances. Unless there's anything else I can assist you with further.
That's quite very helpful now.
Thank you very much, Mr. Zimmer. Very helpful. Right now, Miss Ward. About half an hour tonight, I think, and then we can continue tomorrow.
I feel as Mr. Zimmer said that there's some kind of internal fever bunch about to go on. And I have 3 items on the agenda for that. I hope they will, in covering them, I'll cover everything that's been said by both my learned friends this morning and this afternoon. The 3 items that I have are, firstly, can Article 21 apply on these facts? So where it is the family member and not the insured person who is outside the competent member state. Because of course, if I'm wrong on that, then nothing else arises. Secondly, does that give rise to a need to prioritise? So on that hypothesis, the appellant of course has her own independent right under Article 11.3e, but also potentially the right under Article 21. My learned friends say, well, it's only a hypothetical right under Article 21, effectively, and therefore nothing to prioritise, no overlapping benefits. So that's the second hurdle I have to overcome. Is there anything to prioritise here? And then finally, assuming that I'm right, and there does need to be a scheme of prioritisation so that it's always clear to which member state an individual should look for their benefits, how is that to be done? So, starting then with my first question, can Article 21 apply on these facts? As I understand, first of all, as I understand the defence position, Mr. Berry accepts, or at least doesn't dissent from the proposition that it can. Mr. Mayor's position is slightly more nuanced, and depends to some extent on the answer to my second question. If it's a priority scheme, then it can't. But in my suggestion, it is the right starting position. Does Article 21 do anything in this case? Because otherwise all there is Article 11.3e, and of course the appellant would then be entitled to her Disability Living Allowance, or care component of it. My Lord's really, and my lady, 3 points on that. Firstly, in my submission, it does what it says on its face. So it enables the insured person and the members of their family leave or to not be resident in the competent member state, and to continue to benefit from the right of the insured person in that competent member state. And
So you agree with Mr. de la Mare then that it's a preserving of a right that you would otherwise lose by moving out?
not necessarily moving out. So as on the facts of this case, the appellant's father has moved in and has obtained those rights. And I understand it to be common ground between all of us that there is, and although there are many, many nuances to the way in which different member states organise themselves in this regard, most member states require some form of compulsory insurance for people who are carrying out economic activities in those member states. And that compulsory insurance will very often, will almost always extend to members of the family, precisely for the reason that Mr. Berry gave you this morning, because otherwise, effectively, those coming from other member states would be able to undercut the local labour market, so it would be less expensive to insure. So
Do you say that the word "and" in the first sentence must be read as "and" or"?
I once had an argument with Lord Justice Collins, Mr. Justice Collins, in the Administrative Court about whether "and" could in fact mean "or." I can't remember which of us took which side now. I do remember that several other judges of the Administrative Court
Further
took the
or
opposite position, and nonetheless he found that to be irrational. So I say in this context, yes, effectively "and" doesn't mean "and" in the sense of.
It doesn't mean
Doesn't mean all of
the
them.
whole of the
It
family
means
have got
and
to be living in
also
one
it
place.
means that the other members of the family are covered as well.
Yeah.
Where either the insured person or the family members are outside the state of economic activity, no matter how they got there or who left where.
Exactly.
It's a state of affairs where they're outside, and it could be one or more of them.
Exactly that.
You say, I think, yeah.
Exactly that. And that makes sense.
Yes.
My second submission on this point, because of the rate difficulties that could arise otherwise in a largely insurance-based scheme. And that's illustrated, as I said, in my main skirting argument, by the facts of the case of Hosser, which is tab 21 of the Bundle of Authorities. That was a case under the old Article 19. But these purposes are really material differences, and it's part of the provision. But the facts can be seen at paragraphs.
So which tab again?
It's Hosser, tab 21. And the facts can be seen on page 409 of the authority bundle, beginning at paragraph 13. Mr. Hosser was of German nationality but was employed in Austria. He in fact had stayed residing in Germany with his daughter, who was severely disabled. Her mother was formerly in paid work in Germany and therefore entitled to German care allowance. But when she ceased to be in paid work in Germany, there was no longer an entitlement to care allowance. And the argument was about whether then the father's work in Austria entitled the family to care allowance for the disabled daughter in Germany. Now, on the facts of that case, father also lived in Germany, but had he had to go further for work, had he been residing in the member state where he worked, then the daughter is left with no entitlement benefit at all on these facts.
So in this case, if the child was in Belgium and the father was here, she would be able to claim under 21 to get the care component, and therefore vice versa, she would be able to get whatever the Belgian legislation gives, given that she's in England and her father's in Belgium. The starting point is possible that she could get it under 21.
Yes.
Yeah.
Yes, and that the alternative would be a very serious impediment to freedom of movement.
Yeah.
Because in an insurance book, it would certainly be a very serious impediment to freedom of movement for German people, because leaving economically inactive spouse with disabled child in Germany would mean no benefit for the disabled child.
Yeah.
So I say there's, on any view, a purposive reading of Article 21 must mean that the economically active family member who has gone away and has entitlement under Article 11.3a can use the benefit of that insurance for the economically inactive family members who have been left behind, and that's the purpose of the
If
provision.
you go to a state to work, you get all the benefits of that, and your child doesn't suffer because she's had to stay behind. Yeah.
Exactly that. And the third point on Article 21 is just to pick up on the debate that's been had about derivative rights in this context. And I hope that this is helpful to the concerns expressed by my Lord Justice Lewis. And it's this, which I think is where you've got to in any event, that a derivative right for the purposes of the regulation is a right such as that in Article 21 that arises for a family member. So, take an example where there is no derivative right, in exactly this case, the appellant's mother, on the basis of her residence in the UK, is entitled to claim the full suite of UK benefits. There's nothing in the regulation that says that if the appellant had gone with her father to Belgium, any of those types of right could be exported.
No.
You'd have to find a specific one that could.
Yeah. If the child, it's a good example, if the child had been in Belgium, she couldn't acquire a derivative right to childcare allowance from her mother because she's not economically active, is it, under 21? And the national legislation anyway doesn't give the mother that benefit.
So, and derivative rights, again, will very often arise, or the need to... Derivative rights will very often arise under insurance-based schemes because the economically active family member will insure all other members of the family, will be required to, and the rights would be derivative in that sense. So it's a slightly alien concept to our law, precisely because it's not a directly insurance-based scheme. So that's, can Article 21 apply on its facts? My submission is very plain yes. Does that give rise to a need to prioritise? And this, as the case is now put, seems to be very much the nub of the issue. I should, in defence of Judge Jacobs, I think it was my Lord Justice Baker who asked whether he referred to Article 10 at all. He was not referred to it. So there was no argument put to him that Article 10 will sort this out. I'm reasonably confident of that. Mr. Berry, I'm sure, will shout at me if I'm wrong, but I have checked his skeleton argument in the supplementary bundle, and I couldn't see a reference to Article 10, and that accords with certainly my own understanding of the arguments before Judge Jacobs, which were, does Article 21 apply? If so, how do we prioritise? And that kind of intermediate, do we need to stage, which may well, and I'm not suggesting Mr. Berry didn't mean to run that argument, it may well have been implicit in what he said, but it certainly wasn't how either Judge Jacobs or I understood.
Well, I get the impression that you didn't go through, Mr. Berry wasn't dragged through the,
It was not.
the regulation in the same tortured way he had to endure this morning.
He certainly wasn't. No.
And to be fair to Judge Jacobs, if anyone knows about the regulation, he certainly does.
Well,
True.
Lord yes, and there was I smiled earlier when there was reference to TG as authority for proposition, what Title 2 is a self-contained code, you don't go outside it, and what Judge Jacobs said about that in TG, because of course not only was he the judge in this case, he referred to TG in this case. So the idea that he didn't have that well in mind, and in my submission he clearly did.
Well, he certainly knew more about the regulation than I did 10:30 this morning. But I've had the benefit of an education. So, right, so that's your preliminary observation. That isn't going to get you home on this point.
My lord, no, and
Your next point is, do you need to have a prior right decision, or can you have a choice?
and my lord, the starting point in my submission, as it was for Judge Jacobs, is the principle of single applicable legislation. That's where we start in Article 11.
Right.
And
So you start at 11.1.
start at 11.1. Only one legislation, only legislation of one state should be applicable.
Right.
Persons to whom this regulation applies should be subject to the legislation of a single member state only.
Determined in accordance with Title 2.
My Lord, yes, and I'll come back to that point. So on the first sentence, of course, my Lord, as my Lord Justice Lewis has observed, that's not strictly right, in the sense that persons to whom the regulation applies should be subject to the legislation of a single member state only, but it may be a different member state with different types of benefits. And that's not controversial. And indeed, that is exactly my case on this appeal, that in relation to sickness benefits, because of the operation of Article 21, the appellant and her mother are subject to legislation of Belgium. But that isn't the case in relation to other kinds of benefits, and the specific example in this case is the mobility component of Disability Living Allowance, which was never affected by the issue that's arisen in this appeal, which has always been in payment to the appellant.
And it's not affected because
Because it's not a sickness benefit.
it's not a cash benefit. It's not a.
I think it's a benefit in kind.
It's a benefit if I'm not a cash benefit.
No, cash. It's cash, but it's an SNCB.
Yes, that's right.
What is it?
It's an SMCB.
Oh, it's special non-contributory. It was never moved over into the cash box.
It is a
It's
special. It's one of those that was allowed to remain in that.
Yes, it's not been shifted to create a problem, right? Okay.
But nonetheless, in relation to a category of benefit, persons to whom the regulation applies are to be subject to the legislation of a single member state only. And you referred to a number of authorities for the proposition that, firstly, Title 2 is a complete code, and secondly, the reason for that, just to flag up what the purpose of that provision was said to be by the Court of Justice in the case of, I think this is German, so I can do my best German accent, Versicherungsanstalt in CV.
Where are we?
Auf Deutsch. Tab 25. Paragraphs 45 and 46 on page 508. Should be borne in mind that under Article 11.1 regulation, persons to whom this regulation applies are to be subject to legislation of a single member state only. That legislation being determined in accordance with Title 2. And those provisions, of which Articles 11 to 16 form part, constitute a complete and uniform system of conflict rules intended not only to prevent the simultaneous application of a number of national legislative systems and the complications which might ensue, but also to ensure that the persons covered by that regulation are not left without social security cover because there's no legislation which is applicable to them. Well, My first submission is that this case, the fact that we are in this court for my lords and my lady, is a function perhaps of what happens when it's said that there is simultaneous application of a number of national legislative systems. That the purpose is to have only one that is applicable on the facts of a particular case, not several that may be applicable if an application is made, but to ensure in part that persons who are covered by the regulation know where they are to look for their benefits.
It's interesting, isn't it? If you look at paragraph 47 of the judgment, it says that the court has held that the purpose of the provision is to determine, subject to Articles 12 to 16 of that regulation, the national legislation. No mention there of Article 21.
No, there is no mention there of Article 21, but what I say about that, my lady, is that Article 11.3e is expressly said to be without prejudice to the later provisions of the regulation.
Well, that's
Well,
you have to rely on that, don't you? Because you're dead in the water without it.
Well, it actually says without prejudice to other provisions of regulation guaranteeing him her benefits under the legislation of one or more other member states. So just drawing together the points you're going to have to tackle on that. So we've got them all ready for you, amongst others. The word guaranteeing, one or more other member states, so it envisages where, in its wording, that a person may be entitled to benefits under more than one state. And can I just point out this, that the phrase, there's the first part of the paragraph, subparagraph uses the word shall be subject to the legislation of the member state of residence. And then it says without prejudice to provisions guaranteeing benefits under the legislation of another state. So maybe there's a difference between those two things.
Well, on the face of it, Ms Ward, it appears to be extending the position rather than limiting it. That's the problem. That if it had been subject to as qualified by, I could understand the point, but what it says is subject to but without prejudice to, and that suggests that you're preserving something or adding something.
Well, the way I put this is that the starting point is single applicable legislation.
Yeah.
The fallback category, persons who are not engaged in economic activity and don't fall within 11.3.8d, is in. So that will apply, but without prejudice to. So
why is that a fallback?
Allowing later, but it's been described as that, as a fallback, as a sweep up category. It's
fallback from what?
None of the others.
Fallback from what? Sorry to press on this, but isn't that the primary rule? Because they're not covered by any of the other categories, and therefore that is the rule, the primary rule that applies to them. It's not a fallback for them.
Well, it's the category that a person who doesn't have or can't show that they fall within any of the other categories will fall into. So in that,
It's the starting point. It's got to be the starting point. Yes. So the starting point, and it may well end up being the finishing point, but anyway, it's the starting point, is that for anybody who doesn't qualify under all of the previous ones, the single system of legislation that applies is their place of residence.
Yes, but that is without prejudice, in my submission, to the applicability of the legislation of other member states where that is provided for later than the other provisions of the regulation.
They're both halves defining the same default position. You can't get into A to D, you say, and therefore it will be residence unless there is or becomes something more specific.
Exactly
that's what you're saying, I think.
Well, it's exactly as I was trying to do. Very, very. And
So really what you're saying is that one, is this right? Is that one should read into E after the end of E, in which case, and what it means is in the event of other provisions of regulation guaranteeing him benefits under the legislation of one or more other member states, he or she shall then become subject to the legislation of that member state. There's an immediate problem there because because it says one or more member states, and that contradicts Article 1 on which 11.1 on which you really hang your hat.
Well, except you could have different benefits. You could have one legislation for one benefit, pension, another benefit for something else. I moved to Spain, but my leg is ill, and I've got to get something for that. So it could be that. And you're saying, I think, that all this is, it means residence unless there's something else, and that something else could be for a specific benefit or for different benefits.
And
I think this is what you're
well,
saying.
and what I also say is that Article 11.1 requires then those different sources to be prioritised, because there may then be the situation, as was envisaged by my Lord Justice Lewis, of child cared for by grandparents, two potential rights under Article 21 from each parent. At some point, one has, because of Article 11.1, one has to prioritise those. Now, it may be, again, picking up on what Mr. Lemay said, that this is a vanishingly small issue, and that's why it's not specifically regulated, because it really does only apply, but the issue really only arises in a state in which benefits are largely conferred on the basis of residence. Entitlement to benefit largely depends on residence or lawful residence, and not on contributions by the person or their family members to an insurance system.
Well, the number of cases where you're going to have a residence-based, not contribution-based system, Mr. Delamet says, is small, and for a child to be the person who qualifies on the basis of residence, it's probably only Britain, by the signs of it.
That's so far as we're aware.
Yeah.
My Lord, yes.
So the problem is only Britain, and it is only a care component.
So your way around the apparent conflict between a single member state only in 11.1 and one or more other member states in 11.3e is that relates to different benefits in 11.3e. Is that right?
No, it may be that there are provisions later in the regulation that would appear, or elsewhere in the regulation, that might appear to give her a derivative right on more than one member state to the same benefit, as in the example where two parents
all right.
But
so
if
again,
you're not,
then we do need to prioritise.
so if you're not in A and D, for example, you're 75 and you're not in A or D, you may be resident in Spain, it's warm, and you may have been there for 6 months, but you may be entitled to a pension, and that will be possibly on the basis of the state where you work. You may actually have come to Spain because you've got very bad health care, and you may be entitled from the state that you come from last, because that's where you worked last, but it's not where you've got most of your pension from, to benefits in kind or something else, some other cash benefits, because of that. So all that is saying, you're saying, is a portmanteau thing. When you've got nothing else, it's residence, unless there is something else for a particular benefit.
Exactly
I think
that.
is what you're saying.
Yes, I say exactly that. And then I'm saying that where there is something else, Article 11.1 requires some form of prioritisation exercise.
Yeah.
So it's not simply a choice, it's a prioritisation. Now,
And it's not expressed there, it's got to be implicit then.
yes. Now, as I anticipate, sort of basic rule of advocacy about watching the judge's pen. Now, I anticipate that my learned friend's response to that submission is, well, what does Article 10 do then? How would you ever get overlapping benefits at Article are situations in which that can arise. So, for example, in relation to family benefits, if different members of a family are working for an economic activity in different member states, and therefore there are two sets of family benefits in play, then there are prioritisation rules are obviously required. That's probably far more likely to arise than in general across the union than the specific issue in this case. And therefore, Article 68 in that instance makes specific provision as to how the overlapping is to be managed.
But if it is prioritisation first, before we get to overlapping, why was to be prioritisation of Article 21 rather than prioritisation of the state of residence of the child who is entitled to the benefit, given that's what the law was before, given that's what she needs, because she's a child living in a place with costs in that place, if it's implied?
That is my question 3.
Yeah.
If prioritisation is required, how does one prioritise?
Right. Okay.
And it may be that that's a convenient moment.
Yes. Have you finished what you want to say on your point 2?
I think so, my
Well, well, why don't you? We've all had a long day. Why don't you?
Well, you haven't quite, because I stopped you dealing with overlapping, and that might be part of, must there be some prioritisation, or do you not need prioritisation because you've got overlapping? So I'd probably cut you short with 2, and I shouldn't have, and I apologise for that.
Well, welcome to tour, and I'm grateful for taking time overnight.
Well, thank you very much. I think we will break now. I'd like to say again to acknowledge that it's been a difficult day for everybody, and the way in which you've all responded to our interventions and probing has been extremely impressive. Exactly what I would expect and hope for from advocates of this quality. So we're very pleased. Thank you very much. Look forward to seeing you at 10:30 tomorrow.